Good afternoon, everyone, and a warm welcome to today's webinar. Thank you for joining us for the release of the briefing paper, Balancing Protection and Autonomy, Rethinking the Criminalisation of Adolescent Sexuality by the National Coalition on Advancing Adolescent Concerns and Enfold Proactive Health Trust. The National Coalition Advocating for Adolescent Concerns is a coalition of 22 cross-sectoral organizations from different parts of India working on the rights of women, children, persons with disability, on concerns relating to legal rights, public health, sexual and gender-based violence, sexual and reproductive health, life skills, education, and restorative justice. The coalition members' work ranges from community level to the state and national levels. Before we begin, just a few housekeeping points. Please keep your microphones on mute during the session. If you have questions, kindly type them into the chat box or raise your hand and wait for the moderator. We will take them up during the open house segment. We're delighted to have you here with us today, and we look forward to an engaging and thoughtful discussion. I now invite Shruti Ramakrishnan and Ananda Patnaik from Enfold to give an overview of the briefing paper. Shruti Ramakrishnan has worked in child rights since 2014 and is the Associate Director, Research at Enfold Proactive Health Trust. A Columbia University LLM graduate, she has focused on juvenile justice and child sexual abuse laws, authored key reference books on the POCSO Act, and published widely on child protection. Ananta Patnaik is a senior legal researcher at Enfold Proactive Health Trust with a BA LLB from NLSIU Bangalore. She has worked on human rights and access to justice, contributed to the Indian Feminist Judgments Project, and co-authored a primer on the annulment of child marriage under the Prohibition of Child Marriage Act published by UNFPA last year. Over to you, Shruti and Ananta.
Good afternoon, everyone. Shruti, can we start the slides? So Shruti and I are going to present the outline and main points of our paper, Balancing Protection and Autonomy, Rethinking the Criminalisation of Adolescent Sexuality. I'll be taking you through the context and the unintended effects of the Protection of Children from Sexual Offences Act 2012, which we will refer to as the POCSO Act. As many of you already know, Shruti, can we go to the next slide? The POCSO Act considers all sexual activity with a minor an offense, including consensual acts. And it also prescribes extremely high minimum mandatory sentences. For example, repeated penetrative sexual acts with a minor or sexual acts that result in pregnancy, both of which are possible in a consensual relationship, have a minimum sentence of 20 years. Additionally, anyone with knowledge of an offense under POCSO Act is required to report it. So these provisions in combination create a disproportionate state reaction to what is a very normal occurrence. Adolescence is universally recognized as a unique developmental phase, characterized by puberty, where sexual exploration is natural. Despite this, the POCSO Act conflates sexual exploration with abuse. And high courts have repeatedly questioned whether this is in alignment with the purpose of the POCSO Act to protect children. And their concerns are also echoed by healthcare professionals and civil society. Further, the Committee on the Rights of the Child has also discouraged states from criminalizing consensual sexual acts amongst adolescents. Next slide. Now let's take a closer look at the effects of this excessive criminalization. So as you can see on the slide, it erodes the privacy and dignity of adolescents, results in the deprivation of liberty, aggravates barriers to sexual and reproductive health, undermines the best interest and evolving autonomy of adolescents, and overburdens the justice system. Next slide. So I'll be taking you through these effects at different levels. Now, at the individual level, it has an enormous cost on those who are actually involved in the case. So the victim, after the relationship comes under the glare of investigation, sometimes refuses to go back home, or the family may refuse to take her back. And in these situations, she's usually sent to childcare institutions where she may be judged or humiliated, and often has to undergo invasive medical examinations as a part of the investigation. This causes a lot of trauma for what is essentially a private but normative behavior. It is also problematic to treat, say, a 10-year-old the same way as a 17-year-old and assume that their approach and experience of sex or romance is the same. So it is against the evolving capacity of adolescents as well. Similarly, for the accused, the stigma and violence of being involved in a criminal investigation is extremely punitive and disruptive. Many are incarcerated for months, regardless of an acquittal, and the process itself is a punishment. And the fear of criminal sanctions against one's partner prevents girls from approaching healthcare services. Medical professionals are also torn between maintaining the confidentiality of their patient and mandatory reporting. And all this presents a formidable barrier to sexual and reproductive healthcare. As some high courts have noted, the trial process puts a strain on the family of the victim and the accused and weakens the adolescent support system, making the adolescent even more vulnerable. Next slide. Now, at the society level, these strains lead to breakdown of families. And though adolescent sexuality is universal, it is usually only some communities that get caught in the criminal process, especially tribal communities amongst whom adolescent sexuality is well accepted. They are unable to afford adequate legal representation and get incarcerated for months. Further, the social stigma around premarital relations combined with the criminalization create a sense of urgency and pressurize young people to legitimize their relationships through marriage. Also, various high courts have noted the marriage of the couple as a factor to consider. They are reluctant to disturb a married couple and also grant bail on this consideration. So now there's a skewed set of incentives for young people to enter into a marriage. Finally, instead of creating a supportive environment where adolescents can approach their family or child protection system for access to healthcare or any other concern, they are now worried about triggering the criminal justice system, and this environment of fear defeats the goal of sexuality education and reproductive health. Next slide. Now, at a system level, what does this mean? It's creating barriers to achieving other goals. For example, like Shruti will explain, POXO is being seen as some sort of deterrent to child marriage. Now, though there is a focus on the Sustainable Development Goal of no child marriage by 2030, it cannot come at the cost of other SDG goals like health, gender equality, inclusive, participatory, and representative decision making, and non discriminatory policies. Next, it also places an enormous burden on the justice system. The pendency rate of POXO cases is already very high. And from our romantic cases study in 2022, we know that the acquittal rate for these consensual cases was quite high at 93.8%. And this dilutes the acquittal rate of POXO cases overall. And that ends up eroding the trust of the public in the justice system, who then demand change, leading to more punitive laws, creating this vicious cycle. And the burden here is not just on POXO courts, it's on police, the police, forensic and medical system, and also higher levels of the judiciary. Because the cases of appeal, quashing proceedings, habeas corpus petitions, all these end up in the High Court. Next slide. So keeping all this in mind, we propose the decriminalization of sexual acts with persons between 16 to 18 years of age. Sexual acts with this age group will be an offense only if it falls within certain identified circumstances that indicate that they are not consensual and non-exploitative. For example, if the act is against their will, or whether a child is unable to communicate consent, or whether consent has been obtained through threats, or if the accused is in a position of trust or authority, or whether the adolescent is in a position of dependency on the accused, or in the context of hiring or employing a child for sexual exploitation or the creation of child sexual abuse material. Now, there are concerns, next slide. Now, there are concerns that for 16 to 18-year-olds who have experienced sexual abuse, they will lose the protections currently offered by the POXO Act. But the definition of child under the POXO Act will remain the same. That is, anyone below 18 will still be considered a child under the POXO Act. And all the protections under POXO and BNS, such as the POXO courts and child-friendly proceedings, will continue to apply to them. We also suggest extending the presumption under Section 120 of the Bharatiya Sakshya Adhiniyam to this category of 16 to 18-year-olds. What is that presumption? It states that where sexual intercourse by the accused is proved, and the question is whether it was without the consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent, the court shall presume that she did not consent. Of course, here we would expand the term woman to include a person of any gender between 16 to 18 years. Now, existing provisions that prohibit aggressive cross-examination of survivors and character assassinations should also be strictly enforced. So decriminalization is something we visualize as being accompanied by sensitization and training of all the required functionaries like the POXO special court judges, the police, and the CWC. So this together will ensure that 16 to 18-year-olds are not stripped of their existing provisions while also recognizing their normative sexual behavior. Next slide. Now, Shruti will address other child protection concerns, many of which were articulated in the NCI report on age of consent in 2023. In our paper, we detangle the age of consent from these issues in detail, but here we'll go through these two main issues briefly. Over to you, Shruti.
Thank you, Anandita. Good afternoon, everyone. I'm Shruti Ramakrishnan. As Anandita stated, I will unpack two major child protection concerns which have been voiced relating to decriminalization of adolescent consensual sexual activity. The first is child marriage. On the slide before you are some of the concerns that have been stated with respect to decriminalization and what its impact will be on child marriage in the country. So there is already a concern that decriminalization will increase child marriages because in a sense recognizing consent will legitimize child marriages as well, and parents can now use this provision and conduct child marriages under the guise of consensual relationships, or calling these as love affairs. And resultantly, there is a fear that this will increase the already existing problem of teenage pregnancy, and with it all the associated health risks with early pregnancy and early childbirth. So, firstly, as we all know, we do have a exclusive child marriage law. There is the Prohibition of Child Marriage Act, or the PCMA, which already criminalizes a range of acts, including an adult male marrying a child, and sexual acts within a marriage where one party is below 18 years of age is also criminalized. So, decriminalization will not change what the PCMA currently does. Child marriage will continue to be a criminal offense. The only difference is that instead of all sexual acts within a marriage where one person is a minor being criminalized, only acts which are non-consensual and within a child marriage will continue to being criminalized. Age of marriage laws and age of consent laws can be enforced separately, and they should not be conflated with each other, because the considerations for consent to sexual activity and marriage are entirely different. They involve entirely different levels of responsibility and legal consequences. Before I proceed to tackling like some of the concerns that have been voiced regarding this, I do want to start off by saying that we do acknowledge that there is a inherent harm and a risk with child marriage. Uh, but the question is, how are we going to combat this problem, and what is the cost of using criminal law as a solution in this? So whether it is PCMA or POCSO, the question is this the right tool to tackle this concern? It is also important to reflect on whether this is a helpful intervention, or is it leaving adolescents in a worse off position and more vulnerable. So before I get to this, we have to see the data on what it tells us about the current state of prosecutions of child marriages in the country. So several studies have now examined the trends of how criminal law is used with respect to child marriage. Enfold study of 174 PCMA judgments from 3 states found that nearly half of all the marriages within these cases were self-initiated marriages. So these are marriages which are not arranged by parents or communities, but by the young people themselves with the partners of their choice. Less than a third of the marriages were prosecuted which were family arranged or forced marriages. What is even more telling is who's bringing in these complaints. So we see that in 80.2 of these self-initiated marriages, it is actually the families of the victim which are bringing in this complaint. So this trend clearly reveals that the criminal law, be it the PCMA or even POCSO, which shows POCSO studies which show very similar trends, they are being disproportionately used by families to control their children when they choose a partner of their own, and it's much less frequently used to save and protect girls from child marriages which are forced on by the communities or by their families. The data also leads us to ask, why do these girls run away from home to get married in the first place, particularly when they're still minors and under the age of marriage? So evidence tells us that they're doing this simply because there aren't any better options for them. Many of them are trying to escape much more distressing situations like violence at home or another child marriage that is being arranged against their will. So the very children whom the systems fail to protect, they end up in the criminal justice system because of these laws, which were intended to be for their protection. In these circumstances, criminal action does not really deter these marriages, but only has the effect of punishing those that we really want to protect. To fully address the concern of child marriage, we also need to take into consideration the root causes of child marriage, whether it is family arranged or elopements. Evidence tells us that these are largely driven by poverty, uneven development, lack of employment opportunities for girls, the climate crisis, and the deeply entrenched gender and social norms. None of these causes are directly being addressed by the criminal law. And if we step back and see the data of the last couple of decades, we can see that child marriage is already in the decline. Studies are showing that this decline is because of the structural interventions. Most importantly, is the access to education. When we talk about other concerns like associated concerns like teenage pregnancy, the approach needs to be similar. We need interventions like comprehensive sexuality education, access to reproductive health care, including contraception and abortion, and as well as steps to ensure adequate nutrition. These will help directly tackle the issue and result in better outcome for adolescent girls than a criminal trial which only aggravates their existing challenges. As with child marriage, the concerns that have been voiced for decriminalization relating to sex trafficking are similar. So there are two primary concerns that we see. One is that if adolescent consensual sex is decriminalized and you have a legal recognition of consent of an adolescent, then romantic relationships will act as a legitimate pathway for trafficking by luring them into such relationships, but for the larger purpose of commercial sexual exploitation by traffickers. Second, we have the consent that a legal recognition of a minor's consent will impact the prosecution of child trafficking and permit offenders to claim the defense of consent, which will then act to provide immunity to these offenders. So before I get into these two concerns, I will just briefly touch upon the legal framework. Trafficking is primarily addressed under the Bharatiya Nyaya Sanhita 2023 under section 143. We have another major law for trafficking, the Immoral Traffic Prevention Act or the ITPA, which deals with commercial sexual exploitation. And now below I have pulled out the preamble under the POXO Act, and you can see the POXO Act was enacted to address offenses of sexual assault, sexual harassment, and pornography against children. So at first sight, you can see that the aims of the two legal frameworks are completely different. Unlike the trafficking framework, the POXO Act is unconcerned with the means and the purpose or the organized nature of the offense. There is only a limited intersection between trafficking and POXO. In the trafficking context, POXO will still be invoked if the child trafficked has in fact been sexually exploited. The persons who are involved in this chain of trafficking can be charged with abetment of a sexual offense under the POXO Act if the sexual offense was actually committed. But this is the limit of the intersection. So we have a situation where these two frameworks are completely different. They are addressing distinct harms. They operate in very different legal realms. The POXO Act was never intended, designed, or equipped to tackle a complex crime like trafficking, which is a organized crime. Trafficking requires very different strategic investigative mechanisms, very different support systems. The POXO Act was also not equipped to tackle the chain of actors who are typically involved in an offense like trafficking. So, keeping these legal distinctions in mind, there is nevertheless a concern that adolescent girls are manipulated easily into seemingly consensual relationships, which then become legitimate pathways for human trafficking and prostitution of girls. Trafficking can occur through various means, including even the family of the victim herself. But we can see, and similarly, even sex with adolescents is happening in a variety of contexts. So, some of the sex is normative and non exploitative, whereas others are exploitative. So while some romantic relationships can act as a pathway for trafficking, this does not mean that all romantic relationships with an adolescent is trafficking or leading to trafficking. So we cannot have policies which blur this distinction and are framed on the assumption that all adolescent relationships will inevitably result in exploitation or trafficking. Coming to the second concern, that is the impact on the prosecution of trafficking offenses and what will happen if there is a legal recognition of a minor's consent. So there is a fear that this will be used in defense, used by the defense in court and by accused persons who can now claim that the victim consented. But here we see that the consent of a victim in a traffic offense has been expressly found to be irrelevant. So we have both the BNS and the ITPA saying this. So the consent is for all purposes irrelevant in a trafficking offense. But of course, we have to keep in mind that the defense of consent will be taken, and we do expect it to be taken by the defense in a trafficking prosecution. But this needs to be tackled by strict implementation of the letter of the law by the court, and as well as prosecutors. This really calls for rigorous training of stakeholders involved. Approaches to tackle underage sex should never be confused with trafficking. While sexual activity is not inherently a crime, we see that trafficking is inherently exploitative and no consent is possible, whether it is by adults or by children. So for proponents who still believe that POCSO Act can nevertheless act as the safety blanket and an additional layer of protection for adolescents who are entrapped in trafficking or child marriages, we must now ask at what cost is this additional protection coming in, and are we actually getting any additional layer of protection at all from this? Blanket criminalization of adolescent sexuality for protecting them reveals a complete disregard for the impact of the criminal law on a large number of young people who are in sexual relationships that are non-exploitative and consensual. So in conclusion, continued criminalization of adolescents cannot be justified as a measure to combat child marriage, child trafficking, and other forms of exploitation, as it violates their fundamental rights. Factors that make children vulnerable to underage marriage, early motherhood, and child trafficking require empowering approaches which are based on structural interventions and investments. The proposal to decriminalize sexual acts involving persons above 16 years and below 18 years is in consonant with their fundamental rights to life, liberty, dignity, and privacy, and as well as their best interests and evolving autonomy. I will leave you here, but please do see our policy brief for detailed action pathways to decriminalize adolescent sexuality while still retaining the protective mandate of the law. Our team has pasted the link to the publication in the comments. I will now hand it over to Gopika.
Thank you, Anita and Shruti, for this overview. We will now move into the panel discussion. This panel will be moderated by Anup Surendranath. Joining him on the panel today are Amaidhi, Devaraj, Sangeeta, Rege, Vidya, Reddy, and Swagata, Raha. Anup Surendranath is the professor of law at NALSAR University of Law and teaches constitutional law, criminal law, and the law of evidence. He also heads the Square Circle Clinic, formerly Project 39A at NALSAR. Amaidhi Devaraj is co-director of the Juvenile Justice Clinic at NLSIU Bangalore. A human rights lawyer with 18 years of experience, she leads the Access to Justice for Children project, providing legal and psychosocial support to children in conflict with the law and strengthening the juvenile justice system through research and advocacy. Sangeeta Rege is a public health researcher and former director of CEHAT. She has led pioneering initiatives on health system responses to violence against women, including scaling the NLSIU, India's first hospital-based crisis center, and is currently pursuing her PhD at TIS Mumbai. Vidya Reddy's. Since 2005, Vidya Reddy has been the executive director of TULIR, Center for the Prevention and Healing of Child Sexual Abuse, an NGO based in Chennai, which she founded in 2004. Swagata Raha is a legal researcher, trainer, restorative practices facilitator, and teacher with 20 years of experience. She is a director, research, and co-director, restorative practices at Enfold Proactive Health Trust. Over to you, Anup.
Thanks, Gopika. I assume I can be heard. And right. Obviously, a very interesting issue, and for somebody who's not in the child rights space exactly, and from a very criminal law and constitutional law perspective, the kind of issues that this context raises is quite fascinating and quite challenging for the development of criminal law and constitutional law in India. And the news coming in that extensive arguments on this issue will be heard in the Supreme Court in November makes this discussion more timely. And we're going to try, and as somebody coming from outside the child rights space, I'm going to try and raise some questions as somebody who's of general interest in criminal law and constitutional law, and how various angles to this in terms of sexual and reproductive health and what is happening on the ground. And these are some of the issues that we'll be exploring today through a conversation. I will be starting off addressing specific questions to the panelists. And of course, the panelists are free to come in on if you want to add to any of the responses that have been given. I'd request that everybody keep their questions till the end. We will have 30 minutes. We have 60 minutes of discussion between us, and then we have about 30 minutes of Q&A, and we can take those questions. So there'll be plenty of time for that discussion. So I want to just start off with a question to Swagata and Vidya, really, and take a sort of a few or many steps back to when the POCSO was being drafted, and was this issue something that had come up then? And obviously, the age of consent was being raised from 16 to 18 after many years of keeping it at 16 in our legal system. Was all of this predicted? Was it debated? And why did finally we land where we landed with the POC? So if you could just give a bit of that historical context, might set up the discussion quite nicely. Yeah, Swagata and Vidya. Yeah.
Yeah, I think maybe Vidya can get us started because I think she was part of the drafting process, and then I'll come in.
Sure. Vidya?
Yeah. So, Anup, when the whole process started in March 2010, that's when it actually there were various organizations doing various consultations, but the March 2010 consultation was at the impetus of the Ministry of Law when Mr. Veerappa Moily was Law Minister. So when that started, we were given a deadline of 3 months literally to come up with recommendations. So from March, almost every weekend, we were traveling across India, getting opinions, comments, etc. And in July 4th was the consultation where the ministry, in May, on the end of May, in fact, is when we gave the recommendations to the ministry. And in July 4th, the ministry, at a last consultation, gave back the draft to as they said, to civil society for their opinions and comments. They said, now we want your comments. And this was the sixth draft which the ministry had done. And the draft which the law ministry had was 16. It was very clearly 16, and it brought in all these points which were there in the PowerPoint, that if there was threat, blackmail, coercion, intoxication, etc., then of course it won't be considered consent. And so the law ministry, as of July 4, 2010, in their sixth draft, had very clearly stated 16. By the time the Parliamentary Standing Committee started consultations in 2011, there were obviously various lobbies. There was one, I distinctly remember, there was a person who was considered at the forefront of addressing sexual abuse because being an author of a book on sexual abuse at that time, the only book on sexual abuse at that time, child sexual abuse, who was very strongly against 16 being the age. And I guess there were various other lobbies as well. So when the final avatar came out was 18, it was quite surprising to everyone. And I can tell you on good authority that people who were involved in government for raising it to 18 regretted that decision a few years down that line. Regretted that. And it is very interesting if you listen to the parliamentary debates when POCSO was brought into the Rajya Sabha and Lok Sabha. It was fascinating for those who are interested because you had people like Mulayam Singh Yadav, Lalu Yadav, who fully knew their constituencies and what the ground realities of there, were completely opposing this 18-year age group. And then you had a whole bunch of other people saying, whatever reasons it had to be 18. Yeah, so that's in a nutshell.
Yeah, quite interesting to see how this shift happens at the last minute. So, Agatha, any inputs on that to say what was really driving this at the time of drafting? I guess there are justifications that are built subsequently, but at that time, what do you really see was at play for enhancing the age of consent to 18? Yeah.
I think the turning point definitely was the standing committee's report, as Vidya said, because the government's own draft recognized an exception for those between 16 and 18. And when it went to the standing committee, if you look at the standing committee's report, there were two principal arguments on the basis of which they took the stance that the age, this kind of an exception should not be introduced. One that India has now acceded to the UN Convention on the Rights of the Child. And since the UN Convention, defines child to mean in your law, if it is a person below the age of 18, we're looking at a universal standard, and therefore India cannot have a lower standard in terms of definition of a child. Now, this
Yeah.
is flawed because we do know that the UNCRC is not saying that 18 is an absolute when it comes to the age of consent for sexual acts. It has recognized that we have to balance protection with autonomy, and in fact has repeatedly said in various general comments that do not criminalize adolescents who are similarly aged for factually consensual non-exploitative acts. But that was the first argument. The second was that if you introduce consent, the focus will shift entirely to the victim and she will be subjected to cross-examination as to whether or not she consented. And that would completely dilute the protection that POCSO was meant to offer. So these were the two primary arguments. And I think in addition to what Vidya said, in Parliament, if you look at the debates, many of the things that we are saying today were also voiced in Parliament at
Boy.
that time.
Hmm.
So we are looking at also, the whole weaponization concern that has come
Right.
through so many studies being articulated, saying that, where the whole aspect of honor killing, the possibility that young couples who enter into relationships against the approval of their parents are likely to be the victims of this particular provision if we do not include an exception in favor of consent.
Right. Yeah, I'll come back to the consent point later when we come to this, the recommendations of the report itself. But Sangeeta, if I may just come to you, I just want to put what is a flippant question, but but it's important to just clarify it right off the bat. We prevent 18-year-olds from doing lots of things, from voting, from standing for elections, a whole host of things, drinking, whatever, right? So if we can prohibit them from all those things, right, and say that that's not allowed for you, right, from a health perspective, why should there this exception be for consensual sexual activity? Yeah, I know it's very flippant and it's almost seems like a trick question, but I think it's important to just clarify what's at play here from a health perspective.
So from a health perspective, healthcare workers, frankly, as doctors and nurses, are not, unless there's a medical reason, I would say, would not be extremely bothered with younger people engaging in sex or not sex, unless it is left for them to treat illnesses, diseases, difficult pregnancies, abortions, and so on. So the entire arena of adolescent healthcare, I think 90% of it falls under the sexual and reproductive health. The challenge for medical providers is the forensic piece and the medical legal issue. And that has become, I think, the biggest contention in the last 13 years. And I know you haven't asked me the question, but, while we look at different kinds of prevalences in India, as far as different issues is concerned, intimate partner violence is concerned and so on. So while I was looking for, is there any macro study at a national level to say, how many adolescent people who engaged in consensual sex then fell into POCSO?
Yeah.
And of course, the Enfold report very clearly already quotes two studies from two different states, and many of you may have actually already read it. I looked at the NFHS, which said NFHS 5, which says 39% of women before they turned 18 were engaged in consensual sex. But it's come as a historical context, right? So when they were interviewed, they're probably older, because you know that the NFHS 5 round now does not have a provision for people between 15 and 17 to comment on anything. So it's a flat category of 18 to 49. So the piece around 15 to 18 now is lost as far as the NFHS is concerned. But my colleagues and the team at CEHAT looked at what we call as facility data on medical legal records. And they saw data for 3 years from 3 different large public hospitals. And they found that almost 700, they found a record of 700 case medical legal records across these 3 hospitals between 2021 and 2023. Interestingly, of the 700, 59%, which is 411 cases, were those of adolescents. And
Right.
the range is 13 to 17.
Right.
Now, within the 411 adolescents, 47%, which is a good 191 odd number, were adolescents who disclosed both to the police and the doctor that I was engaged in a consensual sexual activity. But because there's the mandatory reporting, all of them, these 191 people, were brought to the hospital. And, consent is sought a lot of times. They just go through a medical legal examination and so on. So typically the way it plays out in a health setting is this person's gone missing. So parents file a missing complaint. The girl, boy are found. They're blindly brought after a POCSO is registered to a hospital for a medical legal examination. There are some girls who will say, I do not want to get examined, probably are coerced and come back in 48 hours and say, now I want an examination. So I would say that in all of this, the health system, frankly, is at the receiving end.
Right.
And, there is a lot of animosity, I would say, because they feel that their precious time is lost in things that they should not do because there is no therapeutic aspect on it.
Right. Right. So clearly there are very significant health concerns, and as so many of these issues of criminalization, we don't even have the basic data with us in terms of saying how many adolescents are engaging in sexual activity, how much of it is consensual. So we seem to be very often in these criminalization conversations, be stuck without the relevant data that we need. And either the government is not collecting it or generating it, or there's questions around the integrity of the data itself, right? So, Amaidhi, if I may just come to you on the criminalization question. I mean, one could imagine in a parallel universe that even if we didn't want adolescents to engage in sexual activity, we could find non-criminal ways to go at this problem, right? And that we didn't necessarily have to criminalize it. But on the question of criminalization itself, even in this context of child rights and particularly juvenile justice, you see the willingness of the legal system to sort of use this blunt tool, and especially I'm talking of sort of even in the context of heinous offenses 16 to 18, you see criminalization of children and putting them into the adult criminal justice system. Is there a larger concern with the approach to criminalization in the child rights space itself, that from what you're seeing from the lawmakers, that there is a willingness to use this tool bluntly, even for uncertain social gains?
Yes, I completely agree with that, Anup, because we work with the juvenile justice system where the boys are being criminalized for consensual cases, and majority, I would say 97% of the cases that we have handled are consensual cases where the children are being criminalized. And when I say children, I mean the boys are being criminalized. And most of these consensual cases are adolescents between 16 and 18. And they have to go through the whole preliminary assessment process. And, bail is denied because of this. And most of these children, and I think almost all of the children, come from socially and economically disadvantaged backgrounds. So it's very easy for the system to criminalize them, and because they don't have a support system, they don't have, legal representation. So it's very easy to kind of push them and say that, okay, these are criminals. And I can give you some examples. The children themselves start believing they're criminals because sometimes when we ask the children, like, what is your case? They say rape and kidnapping. So then we try to dwell deeper and we ask them, okay, why? I mean, did you rape someone? How did you kidnap this girl that you're saying? And they're like, no, ma'am, she's my girlfriend. Then I said, but why are you saying rape and kidnapping? She's saying, they say that because that is how we are called. We are called a rape case or a kidnap case. So it does really re-traumatize a lot of these children who already come from these kind of backgrounds. Then they have to go through the whole preliminary assessment process, which takes a couple of months. And most of the JJPs deny bail till the PA is completed, which can go on for months together. There is a case where the PA has been lost, and it's 1.5 years. The case is just waiting for the PA. The boy is now an adult, and now PA cannot be done because it defeats the purpose. So they have to go through this entire process, which is a lot of traumatization, not just for the boys, for the girls as well, because we also interviewed a lot of girls who have gone through this process after consenting and having a consensual relationship. And the girl says, I am at fault just for loving this boy. I have put him in jail. So there's a lot of guilt. There's a lot of unhealthy view towards sexuality after this. There have been boys who have come up to me and said, I'm never going to look at a girl again because I had to go through this just because I fell in love with someone and held her hand. So there is a lot of this kind of trauma, and we see the data shows that majority of these cases there is acquittal because it's consensual. Finally it ends up being the court realizes it's consensual and there is acquittal. So the lawmakers have to look at this. I mean, when there was a public outcry after the Delhi rape case, they put in section 15 as a special section for criminalize like 16 to 18-year-olds. So why can't the lawmakers look at this when there is sufficient data to look at a special section for consensual cases?
Right. So, Swagata, clearly, there are sexual and reproductive health consequences. There is the kind of consequences that Amaidhi was talking of, both for persons who are accused and persons who the law perceives as victims. There are complications there as well. But would you agree if I said that everyone agrees that this is now a problem? Or would you even doubt that there is no agreement on that there is a problem? What I'm trying to ask is the disagreement only on the solution part of it now, or is this even a problem we need to look at, or should we just let things be as they are? Is there consensus on it being a problem at all? Yeah.
I think we have definitely come a long way in the years since POCSO has come into force. There is definite acknowledgement that genuine romantic cases exist, because I think when we started our research, our advocacy, at that time there was even questions being asked that is this really happening, is this really romance? There is no such thing as romance. This is all coercive, this is all exploitative. We've come a long way. So I think even if we look at the government of India's position, or we look at the Law Commission of India's position, or other interveners, they are at least saying that yes, there are genuine cases. Criminalization is taking place. I think the Law Commission of India has very expressly recognized that the problems with criminalization. There is definite disagreement in terms of what the response should be. And in that response itself, I think it is telling us a lot about how different people are approaching the issue of adolescent sexuality.
Right.
Whether we are coming at it from the point of view that, normatively, this is behavior that should not be criminalized because it would then absolutely erode their sense of dignity and self-esteem, or we're coming from a place of panic where we feel that any form of recognition or acknowledgement would lead to increased teenage pregnancies, increased child marriages. This will become a pathway for child trafficking. So we are acknowledging the problem, but I think the framing, the way we are looking at adolescents is very different. Some of us are looking at adolescents as objects of protection, not looking at them as right holders and what it means to balance their autonomy with protection. Some of us are looking at them as right holders in terms of having a say in what is an extremely intimate part of their lives, and whether we like it or not. I think the question, another dimension to this, is whether it makes us uncomfortable and whether it's something that you don't agree with or you think is not appropriate. By very nature, does that mean it should become criminal?
Right. Obviously, conversations with you and other organizations. I was fascinated to read the Teddy Bear Clinic judgment from the South African Constitutional Court, where the court has problems with 12 to 16, the criminalization of 12 to 16, and interesting that we are now even having this conversation about 16 to 18, right? And I thought it was a very interesting judgment in terms of how it analyzes the interest, and as you said, as treating adolescents as rights bearers as opposed to just objects of protection, as you put it, right? And I think that really lies at the crux of the constitutional issue that we're talking about. Vidya, I just want to come to you to understand. Obviously, there are all these um, terrible consequences that are playing out because of the law, and I assume on the ground, the way people engage with this law, get around it, or don't get around it, raises its own reality. Then, compared to what the black letter law is, I assume there is a different set of social practices or institutional practices that develop in different contexts. So, given your work in Tamil Nadu, can you just tell us how this is playing out on the ground in Tamil Nadu?
So Anup, what happened? So I mean, whatever Swagata has said and what the other speakers have said is all happening in Tamil Nadu, no doubt. But there has been a history
Sorry.
Madras High Court, who actually said that this is ridiculous. POCSO was not created to, criminalize
Vidya, we
adolescents
just lost you
expressing
for
what
a
is
few
normative
seconds.
human sexuality and stuff like that. So that was, I think, way back, if I'm not mistaken, Swagata, 2018 was Justice Parthiban's order. But I think the real watershed Hello?
Yeah, Vidya, can you hear us?
Yeah, can you hear me?
Yeah, we lost you for a few seconds. Could you just repeat what you said over the last? Maybe if your connection is not great, we can switch off your video. That's yeah.
Yeah, I will, but okay. So where did you stop hearing me from?
We heard the reference to Justice Parthiban's order. Yeah.
Yeah. So Justice Parthiban's order was way back in 2018 or 19. And I think that pretty much is how a large swath of the Madras High Court judiciary has been looking at adolescent sexuality, save here or there a few other judges who think otherwise.
I'm sorry to intervene. We didn't hear what the order exactly said. Also, we lost you.
Oh, okay. So the legal part of it, Swagata, can you just chip in and say the legal part? Basically, he said adolescent sexuality, POCSO was not meant to criminalize adolescent sexuality. To put it very pithily, I'm not a lawyer, so I'm just stating what it said in a nutshell. Yeah. But the watershed moment, I think, for Tamil Nadu has been since 2022. In 2022, there was this it was quite now looking back, it's really funny. And the couple is now married. In 2022, we had a case, it's called the bus stop case, where a young couple, the girl told the boy, I think you're interested in somebody else, you have to prove that you love me. And she brought this yellow thread and she said, tie it around my neck in the bus stand. And so, in full public view of the bus stand, this boy tied the thing, and all their friends throw rose petals, and it was videotaped. It was some stupid school kid prank. But that video went viral, and the collector of the district at that point in time said, "Oh my God, will think kids in our district are really promiscuous." POCSO case for tying a yellow thread around somebody's neck. Now, from that, when we first saw it in the paper, fortunately, the news agency which had covered that had also said these two were in a relationship from when they were in class. So we got really interested in this. So using our contacts, we found out where they were in the boondocks of Tamil Nadu and head off and found out, much to our shock, that nothing in the JJ Act 2 had been observed. The family of the girl didn't know where she was. The boy had been thrown into an observation home. He was undergoing a potency test. I mean, it was complete flouting of every possible, enabling feature or regulation which was available. So we helped the girl's father file a HCP in court to find out where his daughter was. I mean, seriously, he didn't know where his daughter was. Now, fortunately for us, we had a wonderful judge at that point in time who was on the bench, who converted that whole HCP and dealing with that particular case into a special bench, which looked at adolescents in intimate relationships. So that special bench still sits. That special bench has been quashing cases of when both parties are below 18. They interview the families, they bring them to court, or they do a video link, they interview the families. It's been a tedious process. But I must tell you, but even before that, in September 22, when a senior police officer, Mr. Azra Garg, he heard about this horrendous case of this young boy who, because he had this summer romance with his neighbor's daughter, was, of course, the mother, in all her righteous indignation of a mother of a daughter saying, oh, my daughter was lured, etc., had filed a case. This boy was taken to the police station and he was kicked. Now, I don't see any reason why a young boy who's just expressing a normal reaction of any young person of that age in terms of a romantic relationship gets kicked. So anyway, Mr. Garg took this very seriously, and then I think his earlier period in the CBI, he was looking at 41A, how 41A is used in many of the CBI cases where they don't actually arrest the person, but they ask them to join the investigation and inquiry, and if they don't cooperate, then they arrest them. So he started issuing 41A for these cases, saying that the police will use their discretion to understand what would be romantic and consensual. And from that, it then snowballed along the same time as this HCP was happening. It then snowballed into the High Court, POXO High Court committee passing a resolution saying, yes, we should not arrest in these consensual cases of young people. And there they didn't have any age. That's the interesting thing, Anup. They did not have any age limit. I mean, if you were 14, 15, 13, it didn't make a difference. It was between, if it was considered a consensual romantic relationship. Now, this was in November 22, is when the High Court committee, after Mr. Garg presented to them, went passed this resolution. And then in December 22, the DGP of Tamil Nadu actually passed a circular to all police stations saying that, yes, in consensual romantic relationships, no need to make a hasty arrest because nobody's going to run away. They're all invariably people in either child marriages or romantic relationships, but it left it at the discretion of the investigating officer. If they needed to arrest the person, they had to get the endorsement of the supervising officer, which was the DC in the cities and the SP in the district. So this has been a really watershed moment in terms of the special bench being created as well as 41A starting to being issued in Tamil Nadu. So right now in Tamil Nadu, in consensual romantic cases, not just young people of between 16 to 18 or even lower, or where the age difference is not too much and the investigating officer believes that there is consent of some sort, people are not arrested. Yes, an FIR is filed, trial proceeds, etc. Some of them get quashed. But the point is, they're not arrested. Now, we actually went ahead and visited some of these families where 41A was issued just to understand the impact. I can just tell you one particular incident which has really stayed with me is this young woman who had had a baby and whose husband was in the imminent risk of being arrested if 41A was not issued. She was so stressed out, she had stopped lactating because she was so worried what will happen to her husband. And I think soon as she realized that he was not going to be arrested and that the case will take its time, it was wonderful that she was able to start feeding the baby again. I think that shows the kind of impact, this criminalizing can have, just not just on the individuals concerned, but the entire ecosystem. Let us face it. Anything, unfortunately, in India, when you have various stakeholders at play and when there is money also in the bargaining, there will be some rotten apples which will kind of make hay while the sun shines, so to speak. But on the whole, I think it has worked greatly. The police are very happy. They don't spend so much of time in remanding and going through that whole process. Yeah, I think it's worked very well so far. Yeah.
So, I mean, clearly one can imagine that these innovations that different stakeholders and victims or survivors, all of them have to do, that you play around with how the law is used on the ground, also then has the potential that it could actually affect the genuine use of the POXO as well. And then you're forcing these negotiations and you're forcing these innovations because your law is not sufficiently narrowly tailored to address the real harm that you want to, and therefore you're then forcing these innovations that could have other ripple effects that you don't foresee. In terms of the Amaidhi, if I could just bring you in on this justification of child marriage and child trafficking, and therefore that we need to have this provision of criminalizing adolescent sexuality. And as this argument finds its way into court, as the justification for criminalization. What is your expectation in terms of to what level do we want to see this justification being played out, right? In terms of what should the courts actually demand in terms of justification. If you're saying if the state wants to invoke these arguments, just stating them as is that there is a possibility of a connection is not good enough for criminalizing all adolescent sexual activity, right? That there is this modicum of possibility, and therefore we will then bring in a lot more activity that should not be criminalized into its fold. Do you see the court demanding that kind of justification in terms of saying you really need to prove a stronger connection between this sort of criminalization and child trafficking and child marriage?
So I think there's a lot of questions around grooming, right? That's where consent becomes it's not black and white. There's a gray area because of the grooming, which then might go into child marriage or trafficking. But I think from the report itself that Enfold has released, we see that this cannot be a justification because one is it should not depend on. I think the Child Marriage Act and the Trafficking Act is strong enough to kind of to play out on its own. Like, it cannot be a justification for criminalizing adolescent sexuality.
Right.
And again, if we look at the data, nothing else, if we just look at the data, we see that criminalizing adolescent sexuality is re-traumatizing the adolescents. So this is, I think it's a very weak justification,
Right.
and it should not be kind of brought into decriminalization of adolescent sexuality.
And Amaidhi, if I may just ask, with your experience with the juvenile justice system, obviously the offenses come with pretty serious mandatory minimums, right? Some of these offenses come with very serious mandatory minimums. What are the effects that you're seeing, and mainly, as you said, on boys? What are some of the effects you're seeing of this kind of arrest under this? You spoke a bit to it, but if you could just, and I think that we tend to, if you could just bring a little more focus on that, what kind of effects are we seeing on these boys when they're pulled into this kind of criminalization?
Yeah. So Anup, it's not only affecting the boys, it's also affecting the girls who are in the consensual relationship. But the boys, yes, more so because they are institutionalized, as I was saying. So, and then there is this long drawn out process because this is a heinous it's a heinous crime. So it's if the PA is completed and they can be tried as an adult, it goes into the children's court, and their minimum can go up to 20 years as opposed to 3 years if it is a non-consensual case. But so it is, as I had already mentioned, it's very traumatic for the boys because if it is a consensual case and people are telling them that you have you are tried for rape or kidnapping, that is already like mentally their mental health is suffering because they are wondering what they did wrong and why this is happening to them. Secondly, many of them, as I said, are 16 to 18, so they are either in 10th standard or first PUC there, so they are so embarrassed to go back to college, go back to the community, so their entire education, their life gets derailed. And generally their attitude towards their sexual health or also derailed because they think what they did was wrong, and they don't understand why, because nobody's talking to them, nobody's telling them about and giving them education about safe sex or about sexuality itself. So I think overall, when they enter the justice system because of a POCSO case, they really leave it being completely traumatized, and also there's no follow-up or rehabilitation for these children. So there's no counseling, there's no follow-up or rehabilitation. So it does kind of when they leave it, they do go out feeling extremely traumatized.
No, and I think what you said is quite fascinating and tragic in terms of that internalizing of being criminalized, right? That you internalize that you are being branded a criminal for these kind of offenses, and as you said, rape and kidnapping. Sangeeta, I mean, just in terms of, you know, given that the Supreme Court is, you know, very often in these cases in understanding these socio-economic and socio-cultural realities, it really does not perform too well. From a very health perspective, what would you want judges to understand really when this case comes up, or even the lawyers, and even in our own work in a very different context? It's very often the most difficult part is convincing your own lawyer to, or making them understand these interdisciplinary perspectives on a legal issue. So ideally, what would you like in terms of health perspectives to be placed before the court and the lawyers themselves arguing these cases? Yeah.
So I would say two things. You all know about the medical boards, and there are permanent medical boards, there are temporary medical boards, which see especially cases around sexual and reproductive health in connection with medical termination to pregnancies. And, you know, there are no guidelines for how these boards operate, and they comprise of psychiatrists, gynecologists, surgeons, and others. When the medical boards were set out by the courts, they did not think of constituting any expert committee to say what should be the guidance document. So most of these medical boards operate completely based on what they think at that point in time. So you will all remember the Haryana case of a 14-year-old young girl who was sexually assaulted, ended up with a pregnancy. She had a congenital heart disorder, but PGIMR Chandigarh said it's safer to continue a pregnancy than abort, without citing any medical reasons for how it's safe. And we all know that pregnancies after 24 are not actually, when they are terminated, they are not called MTP. There is another procedure by which you carry out early deliveries and so on. So they're quite safe, and there is global evidence to indicate that. So I would say that that's a big fallacy, and all of us are now left at the discretions of these medical courts, medical personnel. The second is the courts themselves also sometimes opining on cases to say when is, I think it's just yesterday, it's a matter that's happened in Maharashtra or Haryana, I don't remember, a 29-week pregnancy of a sexual assault survivor, where the court in itself has gone ahead and said that you cannot terminate it. Almost taking a position which is more pro-life, and saying that we will, and of course the medical colleges then said we will keep her for another 3 weeks, you know, we will ensure that there is safe delivery, and it's left to the mother, who is that 17-year-old child basically, or adolescent, to decide if she wants to keep the baby or she wants to give it for adoption. The courts do not recognize the impact of an actual delivery, the physiological changes that it brings, the emotional changes that it brings. We run a crisis intervention center where young girls who've had late abortions are constantly asking us, Didi, will somebody else come to know when I get married that I had an abortion? Because, will the stitch be seen? Do I need to disclose this? None of these concerns, I think, are even recognized or understood by the courts or the medical system. Lastly, I want to give you an example that overzealous medical systems here in Mumbai, we have a case of a 17-year-old who did not have an Aadhaar card, has gone in for delivery, was never registered for antenatal care because she did not have an Aadhaar card. This is a metropolitan city like Mumbai. She delivers. She says, I'm 18 and a half. Doctors are suspicious because she does not have anything. Turns out she is not an Indian citizen. She's a Nepali citizen. Overzealous medical system goes on with the Nepali calendar, tries to calculate her age, comes to an assumption that she's 14 or 15. Send a call to the police. The police say she's not an Indian resident. POCSO does not really apply in her case. They could have just, you know, and this girl had produced a marriage certificate from somewhere. Her parents were there. Her potential husband or whoever boyfriend was there. Now they've written to the DCP to say, give us in writing that you are not going to record a POCSO, only after which we will discharge her from the hospital. You look at the overzealousness of the medical system, how the police are responding to all of this, and this entire family is traumatized, telling the counselor that we should have just gone back to Nepal for this delivery because now we are stuck. And now if this boy is put in jail, one doesn't know when he's going to get bail. So I think that the courts, the lawyers really need to understand ground level reality of what's happening. There's a certain class that's coming to public hospitals with more affluent and well-off adolescents. There are different techniques that we use. There are organizations and institutions where we are able to at least ensure medical abortions and other procedures for them. But that's not so for a large majority who actually enter the medical system.
Right.
Anup,
Swagata.
I just want to say one thing, but to continue with what Sangeeta said, we have a very peculiar situation in Tamil Nadu, where Tamil Nadu has a very good track record of as soon as a pregnant girl comes into the health system, she's issued a PICME number. Uh, PICME is an acronym for basically, antenatal care and everything like that. So what happens is, suppose the girl is really advanced in her stage of pregnancy, and an MTP cannot happen, and she has a baby. The pick me number is given. She may give up the baby for adoption too. But the fact is that, say she gets married 3 or 4, 5 years down the line, and she gets pregnant in that marriage situation and comes back, this pick me number shows up again. So the marital family, which may not have known anything about her past, now knows. So that's a strange situation we're facing here. Thanks.
Yeah, no, that's interesting. Swagata, in terms of how much of this is really getting into court, what should get into court, how do we get judges to understand this, lawyers to understand this? Any thoughts on that? Of this kind of expert evidence coming into court? Yeah.
I think what will really help the court appreciate the impact is stories that, Sangeeta and Vidya are sharing. That needs to come into the imagination of the court, because it's very well to say we want to protect children from violence. I don't think anybody in this group is going to say that we are okay with children getting violated. That's not the debate here at all.
Yeah.
So, and I don't think anybody is saying it's all right for young girls to get pregnant and, bear with it. None of us are saying that. So we have to understand that the court needs to go beyond these overarching statements being made to understand, is POCSO really advancing children's access to health services?
Right.
In what way is POCSO preventing pregnancies? Because if we look at it now, and we've been saying this, there are many states that are, putting out data saying pregnancies are rising from year to year. So the law exists at the moment. In what way is the law deterring pregnancy? Is the law contraceptive? Like, is that our imagination of the law, that the law, by virtue of existing, is going to prevent pregnancies? Nothing can prevent pregnancies except, comprehensive sexuality education, access to services, contraception. There is no other way of preventing pregnancies. So why are we looking at the criminal law to serve as a tool to prevent pregnancy? So I think the court needs to go beyond these generic statements that are being made to understand that, okay, if I say that I need to keep the age at 18 to make sure girls are not getting pregnant, we know from CEHAT's work, we know from other various reports that have come out that tell us that, if anything, POCSO deters them from coming into formal healthcare services. So you are driving it underground. Or you will suddenly see that data is coming, which is only telling you that all pregnancies are 18 and above, because service providers are prioritizing service over having to report. So POCSO is shifting focus. If our focus is really protection of children, are we keeping the child at the center? Or our focus has now become, okay, where should this FIR be filed? What is the jurisdiction? Did the offense take place in India or somewhere else or some other state? Who should I report to? Where will the products of conception go? The child is lost in this entire picture. So let's not also make it seem as if we are trying to advance protection, when in reality, one starts to apply these laws, we realize that the child is absolutely in the backseat. The legal procedures is what takes precedence. Even for a healthcare provider, it's not easy. It's a huge risk to provide any kind of service and make that decision as to when to report, whether to report. It doesn't exist.
So,
Anup, if I could just add here.
Yes.
I completely agree with what Swagata is saying, because, in the JJBs also, there's this fear with the POCSO law. They are just like, they're so scared to bypass any of the procedures, even in consensual cases. So, for example, previously I had mentioned the PA, which has not come for the last year and a half, right? So we've been asking the magistrate saying, okay, close this because the PA is lost and move on to the next stage. But then they say no, because it's a POXO case, PA has to be done. And in one more case, which was a consensual case again, the girl is saying that I went on my own accord, but because consent is not recognized, the judge is refusing to take that statement. They're telling me, no, you prepare the girl, you tell her what else to say, like she doesn't know the boy, but they just don't want to accept consent. So there's almost this huge fear of not going across according to the processes in POXO.
In POXO,
Yeah.
right. Swagata, clearly a law that was meant to protect children is clearly exposing them to a lot of risks. It seems as though that the jurisprudence around what is in the best interest of the child almost is getting overwhelmed by larger social anxieties for which there might be sufficient basis or not, be it the need to prevent teenage pregnancies or child trafficking or child marriage. Those larger social interests seem to be dwarfing the best interests of the child. Is this largely attributable to the manner in which the courts have built this jurisprudence around best interests of the child, that it's so easily sacrificed at the altar of broader social goals?
So I think the best interest of the child is a much abused phrase, and it has become a catch-all for anyone to justify any stance that they take from the point of view of a child. I think it is very less understood as to what it means. But if we look at the jurisprudence around best interest, it is meant to be a substantive right. If there are other rights at stake, then the best interest becomes a right that be it the judiciary or the parliament or individual authority has to consider. It is a rule of procedure. It is an interpretative principle. If there are two interpretations possible, take one that advances the best interest of a individual child or a group of children.
Right.
Now, having said that, it has multiple components, and I think what has also convoluted the conversation on this issue is the use of the word child.
Right.
The minute you use the word child, then I think concepts of autonomy, decision making, everything gets mired in confusion, because you're recognizing this is an age where they are vulnerable. They're prone to making their brains have not yet developed, they're not yet mature. So the minute you use the word child, it changes the way we are looking at this category of people who are actually distinct, who are
Right.
not physiologically, biologically, neurologically distinct. But the law is
Right.
not recognizing that. So if we
Right.
term them as adolescents and recognize that adolescence is a unique stage, and best interest requires lawmakers to also consider what is unique in the way in which this category is situated. So it's not
Right.
one individual child. And I want to say this because I think a lot of the conversation has also focused on the need for a case to case based approach.
Right.
Values in a case to case based approach. But when we have to take a policy level decision, first of all, we have to acknowledge that the law does not really create any room for a case to case based approach. What we are
Right.
seeing is innovation on the ground, or humanitarian application of the law. But the
Yeah.
law as such has not created any case to case based space in itself. So when you're saying I'm going to take a case to case based approach, you are again trying to say that the entire legal system is going to sit in judgment
Yeah.
about your capacity to make a decision.
Right.
Uh, the question is, at what point should the law withdraw and say that, with age and experience, we are going to trust that there will be some level of ability to make decisions. They may be imperfect decisions, but the protective net of the law will still cover you. So you have
Yeah.
taken a decision. You feel that, okay, hey, I thought it was consensual, but it's not consensual. The law does not withdraw support. Now,
Yeah.
it's another matter how effective our enforcement is. Like, the argument that it will become about the conduct of the victim. She will be subjected to cross-examination. There are provisions even for adult women. Uh,
Yeah.
the law has that you cannot ask them questions about their character if they,
Yeah.
related to consent. where is the judicial sensitivity in terms of enforcement of that?
Enforcement. Yeah.
So whatever is not working cannot be used to justify continued criminalization.
Yeah.
And in the
Yeah.
name of best interest. So in which, in how can we justify criminalization and say that is in the best interest of a young person? So yeah.
I assume if I were to think from the other side, the argument would be that removing this would only worsen it, right? That the problem is bad enough now, and that I assume that's the argument, and one can see why that sort of response from the state wouldn't make sense. Sangeeta, in terms of, I mean, obviously, this is now complicated with the mandatory. This, in combination with mandatory reporting, is really the double whammy. Really, is there a case to say that there must be a specific exemption for doctors from mandatory reporting, in the sense that if that exemption were not there, it fundamentally takes away any meaningful right to health for adolescents, right? That you're just vacuuming out any content, any meaningful content of the right to health for adolescents if doctors are not exempt, right? Yeah.
So in a lot of quote unquote developed countries, it's already the law that health professionals, doctors and nurses, do not have to mandatorily report to the criminal justice system. They have a channel B where it will be for welfare and so on, right? You also have in actual sexual violence cases, which is the Jane Doe and the John Doe cases, where I want to report it, but I want it to be anonymized. So I think those provisions are already available in other countries. In fact, almost 10 years ago, when Indira Singh was made the amicus and CEHAT was supporting her with the research, we had made submissions on all of these accounts as to why doctors should be actually kept out of the purview of mandatory reporting to the CJS system.
Right.
Today, to the number of people who are accessing service, there is a huge number that doesn't come. And I mean, all kinds of unsafe interventions, morbidities and mortalities happen, which I'm not even sure if they get reported. So I'm saying is that it's established practice in many other countries.
Countries, right.
Submissions were made to the apex court here. But I mean, one really fails to understand how they process this kind of evidence. What do they understand? Because here is the government doing a similar thing in a completely parallel example, where the one-stop centers have been set up across districts. So you have more than 750 one-stop centers by the government of India and the Ministry of Women and Child. They ad hocly use evidence from all other countries to say how one-stop centers are extremely effective. And they just go ahead and set it up with, minimal salaries, huge infrastructure, no reporting mechanisms, no perspectives. But they've used it to say, see, this is happening in so many countries. India also has.
Right.
So you really can't, you can't understand the mechanism with which this government and the courts function.
Right.
I just want to make one point besides this. A colleague and a friend has actually written something about caste. And I don't have an example of caste, but I have something on tribes. We are working in Northeast and in different regions, especially in Meghalaya and onwards. The constant concern and query is that there is a tribal law. There are younger people who are, there's not so much taboo as there is in the mainstream. There are younger people who are engaged in consensual activity. They may decide to marry, not marry. They may not get along, leave the partner, and so on. Now, any pregnancies out of that, unfortunately, have now started getting reported under POXO. And doctors are constantly raising a concern that, what is it that we should do, because we don't want to get penalized. So, this is the angle that is not even there in the mainstream. We're not even recognizing what's happening with in other states.
Yeah.
So, Anup, there's one more thing I wanted to add, to get in the continuation of Sangeeta.
Yeah.
Because of this whole Damocles sword hanging over people's heads when they end up pregnant, uh, I have no evidence to back me up, but I've been told by people in the criminal justice system that very often that there seems to be a greater number of kids entering the illegal adoption pipeline because of this. And that is really, really worrying. In fact, pregnant teenagers are directed to private clinics to have babies and stuff like that where they won't be reported. So I think we need to look at like this is like a hydra, lots of ripple effects of this act or this implementation of the act can impinge on other things as well. And there's one more thing I wanted to say. If you look at the statistics on young, I mean, there are, as I always say, there are lies, damn lies, and there are statistics. You can always scrunch and present them the way you want to. But if you look at the number of cases which actually are happening, com- with the explosion of the fact that young people these days live their lives online, you will see
Right.
there's a very strong connection between the technology aspect and young people and their interest in exploring their identities in terms of intimacy. So I
Right.
think that needs to be also considered. We are living in a very different world from the time even POXO. POXO came into being in 2012. How many people had a
Right.
smartphone in 2012?
Yeah.
Every kid on the road has a smartphone now. Every
Right.
kid on the road is on Instagram, on Discord.
Yeah.
So I
Yeah.
think we need to look at these changing times and lifestyles when we're looking at sexuality, the way it's expressed, or young people expressing themselves.
Yeah. Yeah. Swagata, if I may just present uh, analytical question in terms of comparing the foundations of what we're arguing here in terms of decriminalizing adolescent sexuality versus the arguments around preliminary assessments under the JJ Act, right? And an approach to that age group, to the adolescents in the 16 to 18 age group. Here, one might characterize this as saying pushing pro-autonomy arguments, right, in the decriminalizing context. But in the preliminary assessment JJ context, we seem to be pushing in the opposite direction. Uh, would that be a fair characterization? Would that be a misleading characterization, or is there a way to reconcile these two? I was just curious as to what you thought about that. Yeah.
Yeah, I think at the heart of it, the foundation for both arguments is the same.
Yeah.
Adolescence is a unique stage, and at this stage, there will be pushing of boundaries.
Right.
What they need is support and interventions that help them tide through. They do not need the law to come and say, hey, for your protection, for your action, for what you've done, we will criminalize you. So the
Yeah.
argument is the same. So therefore, you are between 16 and 18, your brain is not yet developed, you are predisposed to making poor decisions, you may be accused of crimes that are exceedingly heinous.
Yes.
I don't think the argument is that, if you are capable of doing these crimes, therefore you
Right.
are also capable
Yeah.
of withstanding the adult criminal justice system.
That's
And
right.
here again, I think we have to, if we are looking at legal frameworks, then we have to look at the purpose of the legislation. What is the reason why the JJ Act was brought into existence?
Right.
We are saying rehabilitation and reintegration is the legislative intention. How is that being advanced by saying you can be tried and punished as an adult?
Right.
And yet we have a provision like that sits with a preamble which says rehabilitation, reintegration in the best interest of the
Yes.
child. So how is that, getting advanced there? Now we look at POXO. POXO has come to, protect children against sexual assault and sexual, various forms of sexual offenses,
Yeah.
including pornography. Are we saying that consensual acts that are non-exploitative is a sexual harm? The whole conversation that Amaidhi had, that,
Yeah.
internalization of the fact that, okay, even if it is consent, it's still rape.
You're right. Yes.
So is that the understanding of law?
Right.
That there is no difference between sexual assault and consensual acts.
Right.
If that
And
is the understanding, then I think surely there is a contradiction. But if
yeah.
the understanding is that this is exploitation, this is not,
Yeah.
then to say that recognize the unique nature of adolescence and you take positions that advance their rights. I think
Yeah.
the common factor is advancing of rights and not taking positions that, deprive them of safeguards or push them towards, isolation that comes with
Right.
criminalization.
Right. And I would think that the way to look at both are as questions of what are appropriate frameworks of support, right? Rather than looking at criminalization as some sort of a mechanism to achieve social goals, right? Rather than looking at exclusively as to what do children in this age group of 16 to 18 need as frameworks of support. Amaidhi, do you want to come in on this? Yeah.
I think Swagata has summarized it perfectly, but I just want to, add to that saying, who and what are we protecting? Are we
Right.
protecting child rights, or are we protecting, what society
So
wants them
yeah,
to do? Yeah.
exactly.
So I think, so I think Swagata has already
Right.
summarized what I
Right.
wanted to say.
Right.
Yes.
So I just have a couple more questions before we move on to the discussion with the audience.
Anup, I have one more point.
Yes,
I'm
please,
sorry, I keep
please,
butting
please,
in.
please.
Okay, so I want to talk about the fact that, one is that if you just look at the sheer acquittal rates happening in these cases, it's obvious that it's a waste of everybody's resources and time, human resources, the court time, hospital time, child welfare committee times, everybody's time, because anyway the courts have their pulse, have their finger on the pulse much better than
Yeah.
everybody else who's feeling so righteous and sanctimonious about adolescent sexuality. One.
Right.
So I think we need to look at it against what is the cost to the I mean, literally, what is the costing of a case which goes through the whole system and then ends up in an acquittal? It makes no sense, really. One.
Yeah.
The second thing is, I'm really worried about the boys who are being criminalized in these situations. It's invariably the boys, because there is no distinction being shown between young people who are showing problematic and harmful sexual behavior and young people who are expressing their sexuality as a part of their adolescence, and they're all lumped together in the same group, which is very worrying. So you have, say, a 17-year-old who's sexually assaulting a 7-year-old, and a 17-year-old who was, probably kissing his girlfriend, and they both clubbed together, and that's
Yeah.
really worrying. That's really worrying.
Yeah. Yeah. No, I'm glad you brought up the point, Vidya, of what is the systemic costs of this on the legal system, and even the report cites the crime in India statistics of 89% pendency, and almost 1 in 4 of these cases being romantic cases. So clearly, in an already burdened system, you're pushing more and more cases into the criminal justice system. So sort of the first question, and I'm happy for any of you to take it. The report suggests as a way forward that you undertake a sort of essentially a case by case assessment of whether there has been consent or not, subject to the protections of the POCSO itself, 16 to 18-year-olds. But I mean, how do we offset some of the concerns we've seen in consent determination in adult cases, right? And that history of how courts have looked at consent, what amounts to consent, what does not amount to consent, is a very problematic history, right? It's a very problematic legal history. Any particular thoughts of how to protect against some of those really terrible approaches that courts have taken to adopting of looking at consent?
I think the honorable judges should spend some time with teenagers. Honestly, they sit in their ivory towers. They have no idea what young people are like these days, and I think there should be occasional meetings.
I think that's a larger problem. What you have flagged is not unique to the question is now, do we want to subject 16 to 17-year-olds to also uh, that subjectivity of that system that is ridden with biases? I think there is no hiding away from that. But having said that, I want to say that if people are under the impression that it has not already entered POCSO trials, that's wrong. Because if
Yeah.
you see cases of incest, part of larger POCSO studies that we have done, where the victim is an adolescent girl and the accused is a father, the defense strategy is to say that you're bringing this false allegation because you have relationship with boys and your father did not agree to this, and therefore you're accusing them. I just want to say that the point is larger.
Larger, right.
Point is coming from the fact of how women, particularly adolescent girls, are viewed. You are a liar, you're making things up. Clearly you have consented and now you're saying you did not consent. That's an endemic problem, that's a larger problem, and I don't think that again can be the prism for us to say we will deprive you of your rights and we will push you into the adult system, push you into the criminal justice system, because we are not sure if consent enters the picture,
Yeah.
how you will be treated, because consent has already entered the picture. when consent is nowhere in the statute.
But also to look at it from what are some of the special protections to be put in place to mitigate some of those experiences that we've seen in adult rape cases, right?
I think the presumption, the presumption that we have in the which was section 114A of the Indian Evidence Act and now section 120 of the Bharatiya Sakshi Adhiniyam, which says, if you are saying you did not consent, the court will presume you did not consent.
Right.
But
So,
how well is that enforced is a different story. But those protections already exist.
Yeah. My last question is really sorry, Swagata, were you saying something? Yeah. My last question is pegging this as a 16 to 18-year-old conversation, right? And again, goes back to what Sangeeta was earlier saying, that we just don't have enough accurate and relevant details of sexual behavior by adolescents. That and as was also referring to the Teddy Bear Clinic case, where they were looking at 12 to 16 and then decriminalized for that age group. In that sense, is 16 to 18, again, are we still pitching it too high in the terms of the adolescent sexual behavior in that sense, right? That sexuality amongst adolescents is not, I mean, and it's so difficult to make this argument without that evidence as to at what age are children entering into sexual activities, right? It's so difficult to make that case. But any thoughts on pegging this conversation at 16 to 18 and not at a lower age?
I think, to recognize the anxieties that we have around even 16.
Yeah.
And to look at other countries, like it's very well to start talking about Romeo Juliet clauses. But as you said, South Africa, you look at the other countries, their age of consent is 16 and Romeo Juliet clauses are for people who are below 16. So I think where we stand today, we have to take an incremental approach, and we have to see at the moment, at what point is the law entering into their lives. And I think it is at a point where they are slightly older, where they're making decisions that they're at risk of a forced child marriage, or they're being, in what context are these cases coming into the system? It is when they're running away from home.
Right.
And they have to have some, there's an age at which this is happening. We're not seeing 10-year-olds. We're not seeing 12-year-olds.
Yeah.
We are seeing 15, to 17-year-olds being the ones who are leaving home. And why are they leaving home? What is happening in their, situation that's making them leave home? So not to say that those below 16 are not sexually engaging in behavior that is again normative. But if we have to take an incremental approach, then do we look at, the category that is heavily represented in the criminal justice system, and to see that this was India's history. Before the POCSO came into existence, for a good number, 63 years, we had the age of consent at 16. So there is a historical reason why, we can go back to 16.
Yeah.
And, then look at, maybe decades later, look at what it would look like for those below 16.
Sangeeta? Yeah.
I completely agree with Swagata. I think for me, the way I understand it's the lowest hanging fruit. It's something that's not rocking the boat too much, but apparently it is. It was always 16, so bring it back to 16. I want to add to the discussion that it's not only happening as far as the 16 to age adolescent sexuality, sexual practices is concerned. You look at the entire debate on marital rape and the moralistic views around that we do not even want to remove an exception to it. Yeah. So I'm saying that how are the courts functioning? It's with a very moralistic perspective, without examining even limited evidence on marital rape. And I would draw a third example, which is the MTP and the PCPNDT Act. Clearly very different laws regulating very different things, very conveniently being conflated both by courts, by doctors, and so on. And who is at the mercy of these laws? It's people who are accessing those services. Right. So it's nothing else but a similar situation in which today adolescents without a legal age and progressive assent, I mean, that is where we are. And finally, I strongly believe, as Vidya said, that we need adolescents maybe protecting their privacy, confidentiality of information, but a group of adolescents to talk to the courts about what it means and what it entails for them, and not us constantly talking on them.
Right. Amaidhi?
Sorry. So at the JJB as well, we see a lot of younger boys coming in, and being sexually active. And this is also because I feel because of social media and children having access, to pornography and things like that. So they are exploring sexuality at a much younger age. But I think we need to take it one step at a time and see how we can.
Yeah. Vidya, any last comments from you before we move to the Q&A?
Yeah, so I just think that, as Swagata said, incrementally, we push the envelope too much, you're going to lose the whole battle. So you can just win small battles as we go along. Yeah.
Right. As the report also suggests that many of these larger social concerns with child trafficking or child marriage or teenage pregnancies requires larger governance solutions, and is so true of so much of criminal law in India. What needs to be addressed by governance, you bring the sledgehammer of criminal law into that realm in trying to replace more meaningful governance solutions. And for me, this is yet another example of that. And what will really be interesting when the court hears this and decides this is that against this mountain of evidence as to the disastrous impact on children of such criminalization, what will be the standard it demands of the state to show that what interest it's seeking to protect, what is the burden of justification it will place on the state, and will it, as we so routinely see in criminal law adjudication, will the state be allowed to get away with a very low burden of justification by just invoking these larger social problems without really bringing forth any credible evidence as against the amazing documentation that we have now of the terrible consequences on adolescence? So I think that's what, as somebody who teaches constitutional law and criminal law, will be watching out for as to what the court does in this context. So we have about 20 minutes left for Q&A. If I may just request those who want to ask questions to just raise your hands, please, and I'll call on you. Yeah. And if you just keep the questions or comments short, allow us to give an opportunity to many others. Yeah. Any questions or comments?
Wow, Anup, I don't know what that means.
The shy audience. Okay. Okay, we have Nimisha. Nimisha, go ahead. Yeah.
Sorry, I just want to come to say, I think it means it's a little bit of a preaching to the choir situation, unfortunately. And I think the people who seriously oppose our views, I mean, I think, Shalini had a lot of points, but what you see on the ground is extremely concerning. That there are everyone in the system is recognizing that this is a serious issue. And I mean, I have seen in police trainings that policemen from the ground are shocked to know that the government has been asked about this and has responded saying, no, there is no question of reducing the age of consent. So it's really shocking. And I think, I agree with Swagata, we need to take an incremental approach, but it's concerning that, the people who are against maybe lowering the age of consent or looking at the situation, the kind of impact that is happening on adolescents because of these laws, are very difficult to convince. And just the sheer level of protectionism that exists in their responses, it's really challenging. And I mean, I also struggle to think like how do you convince the people who are very seriously opposing this kind of move, and they certainly hold sway, let's just say. Yeah, sorry for the very depressing comment.
Thank you.
I would like to come if it is possible. So,
Sure.
my concern is actually not about opposing or not opposing. I think my concern is how it will roll out. We have some of the best, laws in terms of child marriage, in terms of trafficking, but we all know the ground realities. When it rolls out, it is completely different. So my concern majorly comes from that. We see what happens in the ground. We work in Sundarbans, which is completely a very porous area with the climate change and everything. It is almost on in some of the worst sex ratios that you can see. And what we see over there is that elopement is a very, very common thing. Elopement, child marriage is a very common thing. And it all starts with love. And within few months, it all fizzles out. The boy will leave because most of the boys go out of the state for. So it is so interlinked with each other that it becomes at times very difficult to segregate so clearly as black and white and how it comes out. I think also that means I am quite aware of the Madras High Court judgments recently on quashing the FIRs of the POCSO, but one should study that also very clearly because it also has a lot of issues to look at how those quash of FIRs have happened. And there are some deep concerns about that. So I'm only concerned not on a moral ground of, whether it is good or bad and all that thing. We all have teenage children. We know how it is. Where do they live? What do they talk? But when it comes to implementation and rolling out, it is completely, it actually does not have lot of about also psychosocial thing itself is not there.
Conversation
Shalini, were you done or?
Yeah, I'm done because there were a lot of cross
No, I think
I
no, if
think
there's,
yeah happening.
yeah, no, I think it's you can. If there's anything else you
No,
can.
no, I have said I'm just talking about not on a moral
Sure.
judgment, high judgment. I'm talking about the rolling out of all the best intentions that we have.
Right.
And how does it roll out? It rolls out really quite pathetic at the ground level. And then we should not end up, dealing with another set of another problem after that. So just to be mindful on whatever we are suggesting and looking at.
Swagata, any thoughts on that? That sort of just as when the POCSO was rolled out and there were all sorts of unseen consequences, that if the law were to change on this and we were to roll this out, there could be unseen consequences that we don't foresee as of now. Yeah.
Yeah. So I think I acknowledge the concerns that Shalini has raised, and I think the examples that you give are fairly telling because it tells us the structural factors within which these relationships operate. We know the stresses, we know the constraints, and that again is something that I think the question is whether criminal law is the answer. So the fact that in Sundarbans the girls, what are the options really available for the girls? You said the boys have no employment opportunities. What is their access to education, and what is the positive effort made to change that reality? So if if there is the option is not between say school and marriage. School is not an option at all. So one is looking at marriage arranged by family or marriage to a person I remotely like. So when the options are so limited, I think the question to ask is then, are we making them worse off or better off by bringing them into the criminal justice system? Is that intervention really ensuring that, okay, now they have access to education, they have access to health services, they have access to, whatever their aspirations are? And that again is a ground level question, right? What you said. So the intention of the law is this probably, but on the ground, you don't see any of these materialize. Instead, you see this same girl who's running pillar to post, if at all say they do get married, arranging for his bail or arranging for his lawyer. And I think I did see your comments about what is the future of these relationships. I don't think the law's job is to make sure we have stable marriages and relationships. All the concerns that we flag in terms of the quality of relationships also exist when you cross the age of 18. The violence doesn't go away, the deprivation doesn't go away. So what is the long-term intervention that we want to make to improve the quality of relationships, improve, how power is negotiated in relationships? What are the interventions in respect of that. But if we continue to say sex is taboo, anything before this age is taboo, and it is not right, we are not creating that environment in which young people can even understand how to negotiate boundaries and consent.
Yeah.
Yeah, I completely agree with you, Swagata, on that. But I also quoted in the discussion the suicide rate, which we are actually observing now, the data. And last 6 months data very clearly says that some of the quoted reasons for the suicide for girls as young as 13, 14 is because of the pregnancy fear. So most of them want to take that step because they were in love, pregnant, they became pregnant, and now the boy is not there. And the only solution for them is that. And it is very high. We are just collating that thing. I don't know whether we can still share it, that data, but yes. And it is only a very limited, I'm saying that it is only a 1 hospital, 2 hospital, government hospital data. This is also very difficult to get because it is usually not even published. So it has its own repercussions. That is what I'm trying to say. It is not even about the moral ground of the sexuality. Of course, comprehensive sexuality should be there, which we are running away in India for a very long time. So yeah.
Yeah, I think the same point that I made earlier, Shalini. I think the question is what is the response to pregnancies and suicides? Like is criminalization going to reduce suicides or reduce pregnancies? Because what you have articulated is, again, it makes the case for a strong intervention that is health based and support oriented for young people in the community. Like that would be one of a concrete way of addressing these issues. And again, these point to the taboo surrounding sexuality and pregnancy, which is very real. One is not denying it.
Yeah, there's some very interesting comments and thoughts in the comment section. If any of you have put comments there, would you be great if you want to raise a comment or question here in the discussion?
I would like to discuss something from the point of view of caste. This is Shweta Goswami from Nirmal Initiative.
Sure, Shweta, go ahead, please.
May I?
Yes, please.
Yeah, so my concern is how autonomy is possible for Dalit women, Dalit girls, and also specifically for DNT girls, Vimukta girls, who are outside the moral realm of the society. So when you're criminalized, you're already outside the society. And how sexual subjectivity is happening, and how are we viewing that possibility where holistic development of sexual subjectivity can take place for both Vimukta bodies and Dalit bodies. And if we think of autonomy as relational, then we see that our villages are segregated, and the distance that Dalit girls are covering to reach a school is very different than for the upper caste students. And in such a scenario where there is a geographical distance and there is a division, segregation. So yes, of course, there can be individual likening, but then there is a kinship, there's community, there is intimacy with the community, and intimacy that one experiences in the body towards the other. So my concern is that when we think of autonomy as relational, the Dalit adolescent girls and Vimukta adolescent girls are, and even boys are, in difficult situation to navigate their sexual subjectivity. And they're already criminalized, they're already seen as sexually available. In such a scenario, what I see is important to see, to expand the definition of how we understand consent, and and how we are seeing social power, caste stereotypes functioning in the ongoing lives of the adolescents coming from Dalit, Bahujan, Adivasi, Vimukta adolescents. Yeah, so what I think is that we need to look at the consent, definition of consent from going beyond, oh, you agreed to it, or you went with him, or he went with you. But beyond that, what was functioning, which is caste. And maybe we need to think of POXO along with the POA Act, because that would also, which is usually we take Prevention of Atrocity Act, usko alag kar dete hain, right? But I do think it has potential because it starts with prevention. And when we look POXO and POA together, perhaps there is a space for safeguarding and for the possibility of the development of sexual subjectivity of the adolescent from religion communities. Thank you.
Yeah, thanks. Sangeeta, do you want to take that?
No, I mean, I completely agree. I just wanted to raise 2 points. I think one is Jansahas Ashif's work around the DNT community and young women and girls, and navigating the entire criminal justice system for reporting of sexual violence. I'm not talking about consensual sex, and the entire challenge around that in MP Jharkhand region. So that's a brilliant piece of work that, you know, all of us can look at. And the second, I think in Mumbai, there is the Urja organization, which is a shelter. It's an open shelter service by Deepa Pawar and friends. And they've done some really brilliant work on why is it that young Dalit girls are running away and coming to Bombay from different parts of Maharashtra, and what's happening within their communities when they're accessing formal education, employment. You know, there is, in a sense, a pushback, you know, to continue certain kinds of professions, maybe even sanitation work. And we already have a group amongst the Dalit community which is pushing for reservation within the sanitation. And these are young girls who are actually expanding boundaries and saying that, you know, we're graduates already, we are taking up higher education, we want to be out. So it's a complex issue. And I just thought we should also kind of allude to the work that's already happening by organizations like Jansahas and Urja.
Yeah, thanks, Anita. Dr. Lali, do you wanted to come in on question?
Yeah, I just wanted to ask, you know, when we are considering lowering the age of consent, and are we looking at the close-in age exemption? What risk would you think it would give a rise to? And can we think of, you know, a categorization in terms of an aggravated assault? And I mean, we looked at that in the POXO cases, but when the age gap is 2 years or 3 years, I've seen the profile is very different of the offenders as compared to when the age gap is huge.
Yeah.
Otherwise, we are all classifying them as, like, if they come into the prison, they're all POXO rape cases.
Yeah.
Profiles of these persons are extremely different, but the system treats them as a universal uniformity.
Yeah.
This is something that needs to be understood by not just the judiciary, but by all the functionaries of the criminal justice system. And having a clause like that would definitely be helpful, but there are going to be risks, as have been discussed by others.
Yeah. So I think the report argues against, I mean, or is not in favor of close-in age clauses as a solution, and I'll let Swagata explain that. Yes.
Yeah, so we, you know, the report examines close-in age exceptions and rejects it, because I think we have to look at the unique problem we have in India. And the unique problem is that the process is the punishment. The fact that, you know, you're dragged into the system, you're subjected to an arrest, there is detention, there is medical examination, there's a trial. Most of these cases end in an acquittal. And now at that stage, we want to introduce a close-in age exception. It is not taking away the indignity that comes from being subjected to criminalization for acts that are normative. That's one. Second, I think we seem to lay too much emphasis on age difference. Age difference is one among many. If you're looking at violence within relationships, power can be exercised even by somebody who's younger than you, or is the same age as you. So I think there is an overemphasis on, you know, an age difference, and automatically that means that there is a power imbalance. That's not true. And I'm sure we all have enough cases that we've dealt with that, are a testament to this. So let's look at factors that actually vitiate consent, and that would be a more sound basis of, looking at grounds. So all the grounds that we've spoken of, grounds of people, somebody who's in a position of trust or authority, somebody who's your teacher, could be your tuition teacher also, somebody who's exploiting you for other purposes. Now these are grounds that would vitiate consent, so let's bring those in. But when we get fixated on age, we again, let's look at a composite of all the problems that criminalization cause. Now we want to add more time to the court to determine not just the victim's age, but also the age of the accused, to determine whether they fall within that age bracket. And unlike other countries, I mean, we've done this research, I don't think age determination is as contested as it is in India. They don't even pause and think that, okay, how are we going to prove age? And any of us who've been part of POXO trials or has looked at POXO cases, we know how contested age determination is a thing by itself. There is a jurisprudence around it. Anup has written an entire article on age determination. I mean, that's how complicated age determination in India is. But I think the argument is more foundational, that, uh, what are we saying? That, the court will, you're subjected to this entire process, and the end of it, we will determine whether you fell within that age bracket. So foundationally, I think we need to ask ourselves whether age difference alone is something that signifies that consent is vitiated. I also want to take the opportunity to respond to Ashika's comment, and I would say that, Ashika, I think, the point you're making about neurodiversity and adolescent sexuality, it points to invisibilities of various populations in our research. And I know people have said this. I think, Shweta's input, the other comments that have come in terms of impact on indigenous groups. There are many, many invisible populations, and we're only primarily talking about heterosexual relationships, because that's what we are seeing in the criminal justice system. So maybe our conversation has also become very narrow. We are not able to appreciate what this means for other invisible groups, and how even, the conversation in terms of curriculum should look like. Because yes, we've said a lot about comprehensive sexuality education, but how much are we factoring even persons with disability and neurodiversity within that framework? So there is a lot of thinking through that we all have to do. I think we should just acknowledge that.
I can see a hand up. I can't. It says DSP AKM. I don't know if we could take that as the last question. Yeah.
Yes, sir. Yes, sir. Good evening, sir. This is Jafar, DYSP, from Tamil Nadu Police, sir. I have a doubt. While in my subdivision, we have registered around 74 POXO cases till now this year. So in that data, we have registered 74 cases, but in true sense, there were only 4 to 8 cases which were true POXO cases, and most of the cases were teenage pregnancies or either a case of elopement. So in that case, we had a very specific case in which both of the individuals who had involved in the sexual act or something, so both of them were less than 18. So on investigation, we found out that they were just curious to learn something. They were just excited to do something. We presented a report before the JJB asking for an exception so that both of them are not produced before the JJB. But I think in JJ Act, there is no provision which mentions clearly that apprehension is not a discretionary power of the investigation officer. For example, if that is an adult, we have an option to issue a 41A notice. But if it is if he or she is a individual who is less than 18, apprehension is the only way that we could produce the child before the JJB, sir. Is there any other way that we can produce the child before the JJB? There is something called social investigation report. We don't have much scope to file a report before the JJB because it says either a child protection officer or a CWC member has to file it. So my concern is, if we have found that it is none of the individual's offense or individual's fault, but still we were forced to produce them before the JJB.
Yeah. Amaidhi, do you want to come in on that, or Vidya?
I think Swagata is better.
Okay.
Yeah.
Amaidhi, you want to take it?
So under the JJ Act, apprehension of a child should be done only in a heinous case and only if it is in the best interest of the child. So that is what the JJ Act mentions. So if the police find that it's a consensual case, then they don't have to apprehend the child. So that is what the JJ Act says, and but it is again not being followed on the ground, because even in Karnataka, children are apprehended not just for heinous cases but for serious cases and for petty cases as well. But as per the JJ Act, a child should be apprehended only if it is in his or her best interest.
Yeah. Swagata?
Yeah, I think the same. I think you brought in a very interesting point in terms of, what is available to an adult and what is available to a child in conflict with the law. And I think the confusion also arises because this provision is in the model rules, and Tamil Nadu has its own set of rules. But if you look at the JJ model rules, what Amaidhi just said, Rule 8 addresses this and talks about, apprehension, not just in heinous offenses, but also where it is in the best interest. So if you apply that lens, and I think the idea of the law is to not stigmatize the child in conflict with the law. So if you are able to use 41A and, justify it based on model rules and the best interest principle, it is possible to not apprehend them. Yeah, they have to appear. That is true. Even if they're not apprehended, they will still have to appear before the JJB. But at least they're spared the interface of, interacting with the police and being apprehended.
But then, Swagata, who would produce them before the JJB if they are not apprehended in a heinous offense, if they are CICLs?
Sorry, can you repeat that, Vidya?
So in this particular case, which Mr. DSP was talking about, in that case, they have to be produced before the CWC. Am I right? They don't have to be apprehended, but they have to be produced before the CWC.
Yeah.
Yeah. So how will they be produced before the CWC? Do they come on their own, or do the police bring them? How does it work?
No, it is not articulated, but they also have to meet the definition of CNCP. That is a child in need of care and protection. So maybe a little more facts are needed to understand whether they fall under the category of a CNCP to come before the CWC.
No, not the CWC, JJB.
You said they want to be
Oh, I'm
produced.
sorry. No, you were talking about JJB. You said any which way they have to be
asked to. They can be asked to come on the date and time can be told to them, and they don't have to be escorted. They just have to be told this is the date and time. Parents have to be intimated, and they have to appear before the JJB on that date.
And if they don't, what's the penalty?
If they don't, of course, then the JJB will issue summons. But in fact, Karnataka JJ rules has a provision which says the child on their own can come and appear before the JJB without having, production by the police or anyone else.
Okay.
Thank you. I also agree with Swagata. Even we used to do that. We used to ask, even the police will tell the CLCB, they can come anytime. When we give the time, they can come on their own with their parents.
But it requires a very progressive JJB to do this. In most cases, JJBs will not let you do that. The police will have to apprehend the child and produce. There is no exception across the country. And it is very difficult to convince the police also that they have this option of not apprehending the child, even when you keep on showing them Rule 8 over and over.
But this is possible only when the judge is convinced about it. If they're not convinced, then it's very difficult. Yeah.
We've passed 5. I'm just going to step in and move towards wrapping this up. Thank you so much to all the panelists. And I think, it's a very crucial issue to see when there's such a mountain of evidence of the terrible effects of the law. How will the court and the government respond? And to what standards will we hold the government? It's a very critical issue for that. With that, I hand it back to Gopika. Yeah.
Thank you, Anu. I'd like to thank all of the participants panelists and speakers for joining us today for this session and for sharing their insights. We look forward to staying connected and engaging further on this issue. We will share the link to the report. I think it's already been shared in the chat, but we'll also share it over email. Thank you, everyone.